Welcome to the Deep Dive. This is where we take all that information you've gathered, articles, study guides, and yes, those really important practice test results, and boil it all down to what you really need to know. Today, we're on a very specific mission, one designed just for you. We're diving headfirst into the California Real Estate Sales License Test. And we're going to zero in on those exact concepts from your California Real Estate Principles practice test, the ones where you maybe thought, okay, I need a bit more clarity on this. Our aim today, to turn any lingering uncertainty into solid confidence for test day.
That's exactly right. And look, this isn't just about, going over answers you got wrong. It's about really building a strong foundation, understanding the core principles, seeing how they connect to the bigger picture on the DRE exam breakdown, and making sure we cover those really high-yield topics, the ones that pop up again and again across the principles, practice, and legal aspects study guides. We want you to truly get this stuff, not just memorize it, so it actually sticks with you.
Couldn't agree more. So get comfortable. We're planning to untangle the jargon, give you some solid California-specific examples, and really make these ideas click. We know you did well overall on that practice test. The 75% is a great starting point, but there were definitely a few key themes that stood out as needing a deeper dive. And that's exactly where we'll focus our energy today. Okay, ready? Let's unpack this. All right, first up, let's tackle a core distinction. It's one that honestly trips a lot of people up, and it was definitely a point you flagged for clarification from your practice results. The difference between a title and a deed. So I guess the common thinking is, if I have the deed in my hand, that piece of paper, doesn't that mean I own the property? Isn't that proof enough?
Yeah, that's a really common thought, and it makes sense on the surface. But it's super important to get this distinction right for the exam and for practice. Think of title like this. It's the abstract concept of ownership. It's the actual legal right you have to possess, control, enjoy, and dispose of the property. It includes that whole bundle of rights we talk about. But critically, title itself isn't a physical document you can, hold in your hand. Now, a deed, that is the physical legal document. It's the instrument, the piece of paper that's specifically used to transfer that ownership right, that title, from one person, the grantor, to another person, the grantee.
Okay, got it. So title is the idea or the right of ownership itself, and the deed is more like the receipt or the key. It's the tangible thing that actually makes the transfer happen legally.
That's a perfect way to put it. The deed conveys the title. It's the vehicle for the transfer. But, and this is key, the deed itself doesn't prove ownership all on its own. It's absolutely a crucial part of the public record. Strong evidence of the transfer, yes. But the title is that underlying legal right that's being passed along. Understanding this is really foundational. It affects transaction accuracy, avoids legal headaches. It's how property actually changes hands in California.
That makes a lot more sense. Okay, building on that ownership idea, let's shift to how property can actually be owned or held. This was another area flagged in your results, the different forms of co-ownership. You can own property by yourself, which is called ownership in servalty, simple enough. Or you can share ownership, which is co-ownership. We really need to dig into two main types here: tenancy in common, or TINACUS, and joint tenancy, JT. And then super important for us here, community property in California.
Right. Let's start with tenancy in common. What's really interesting about TIC is that the co-owners can hold unequal shares. So you could have two friends buying a place, maybe one puts in more money, so they own 60% and the other owns 40%. That's perfectly fine with TIC. The absolute key thing to remember here, and this trips people up, is that TIC does not include the right of survivorship. This means if one of the tenants in common passes away, their share doesn't automatically go to the other co-owners. Nope. It goes to their heirs, either through their will or, if they don't have a will, through intestate succession. The only unity required for TIC is the unity of possession. Everyone has the right to use the whole property.
Okay, so unequal shares are possible and no automatic inheritance by the co-owners. And then joint tenancy kind of flips that on its head, doesn't it? I remember there's that mnemonic, PITT, for the requirements. What are those four unities and how do they change things so drastically?
Exactly. It's quite different. Joint tenancy demands all four unities, often remembered by PITT. Possession, interest, time, and title. Possession. Like TIC, all joint tenants have the right to possess the whole property. Interest, this is a big one. Joint tenants must hold equal ownership shares. No 60-40 splits like in TIC. If there are two joint tenants, it's 50-50. Three joint tenants, 1/3 each, always equal. Time. All joint tenants must acquire their interest at the same time. Title. All joint tenants must acquire their interest through the same document or deed. And the absolute cornerstone of joint tenancy, the thing you really need to nail down, especially since it came up for you, is the right of survivorship. When a joint tenant dies, their interest automatically, by operation of law, passes to the surviving joint tenants. It completely bypasses probate, wills, heirs. It just goes straight to the survivors.
Equal shares and that automatic right of survivorship. Got it. And then because we're in California, we have this extra layer, community property. How does that fit in, especially for married couples?
Right, California is one of 9 community property states. This concept applies specifically to married couples and registered domestic partners. Generally speaking, any property, real estate, personal property, income earned that's acquired during the marriage or domestic partnership is considered community property. And it's owned equally, 50-50, by both spouses or partners, regardless of whose name is technically on the title or who are in the money. What's really crucial here is that neither spouse can sell, mortgage, or otherwise encumber community property without the written consent, the signatures of both spouses. One person can't just decide to sell the house on their own. Interestingly, couples can also choose to hold community property with the right of survivorship, which makes it function similarly to joint tenancy upon death, avoiding probate for that property. We also have this concept of quasi-community property. That's basically property acquired by spouses while living outside of California that would have been community property if they had acquired it while living in California. It gets treated like community property upon divorce or death here.
Wow, okay. So choosing how to hold title isn't just a box to check on a form. It has huge consequences down the line.
Huge consequences. It dictates inheritance, who has control, what happens in a divorce, how property taxes might be assessed upon death, everything. Understanding these distinctions, TIE, JT, community property, isn't just about getting a question right on the DRE exam. It's fundamental to advising clients correctly and protecting their interests when they buy property in California.
Absolutely. So sticking with that theme of what happens when someone passes away, what if they don't have a will? That brings us to intestate succession. This concept also appeared on your practice test. Intestate just means dying without a valid will. Does the property just disappear, or does the state automatically grab it?
That's a great question, and thankfully, no, it doesn't just vanish or automatically go to the state in most cases. When someone dies intestate in California, the state has specific laws, the laws of intestate succession, that dictate how their property, both real and personal, will be distributed. It goes to their legal heirs in a specific order defined by statute. Usually it's spouse and children first, then parents, then siblings, and so on down the line. The property only escheats, meaning reverts, to the state of California if the person dies with absolutely no identifiable legal heirs. That's actually quite rare. So if our example person, Quinn, dies intestate, his property gets divided up according to California law among his closest relatives. This really underscores the importance of having a will or trust as part of estate planning. It ensures your wishes are followed, rather than relying on the state's default plan, which might not be what you intended at all.
Right, avoids a lot of potential confusion and maybe even conflict later. Okay, let's pivot slightly to valuing property. Another area that seemed to present a bit of a challenge on your practice test was understanding the difference between a comparative market analysis, CMA, and a formal appraisal. Plus, what exactly does an appraiser do? They sound similar.
They do sound similar, and they both involve looking at property values, but their purpose, formality, and who performs them are very different. Let's break it down. An appraisal is the big one. It's an official, formal opinion of a property's market value. It's performed by a state-licensed or certified appraiser, someone who's met specific education and experience requirements. Appraisals are done for a fee, they're highly detailed, they follow strict guidelines like USPAP Uniform Standards of Professional Appraisal Practice, and they're considered very reliable. Lenders almost always require an appraisal before approving a mortgage loan. Why? Because they need an impartial, expert opinion of the property's value as of a specific date, backed up by solid market data and analysis to ensure the property is adequate collateral for the loan. Now, a CMA, or comparative market analysis, is different. It's typically prepared by a real estate licensee, an agent or broker. It's not an official appraisal, and agents don't need an appraiser's license to do one, nor can they charge a fee specifically for the CMA itself. It's part of their service. A CMA compares the subject property to similar properties that are recently sold, are currently listed, or were listed but didn't sell, expired listings, in the same general area. The goal is to help a seller determine a realistic listing price range or help a buyer decide on an offer price. It's an estimate of market value based on comparable sales data, so it's definitely useful, but it's less detailed, less formal, and generally considered less reliable than a full appraisal. The methodologies can differ, and the agent preparing it isn't necessarily impartial in the same way a licensed appraiser must be.
Okay, that makes sense. So the CMA is like the agent's expert opinion based on recent market activity, a great guide for pricing strategy. But the appraisal is the official regulated valuation that the bank or lender relies on for the loan itself. It's like comparing a skilled mechanic's advice on your car's value versus the certified inspection report needed for insurance.
That's a really good analogy. The appraiser's role is critical in the lending process. They provide that independent, supported opinion of value that underpins the financial transaction. And both CMAINs and appraisals rely on fundamental valuation principles, like the principle of substitution, the idea that a buyer won't pay more for a property than it would cost to buy a similar, equally desirable substitute property, or the principle of contribution. How much does a specific feature, like a new pool, actually contribute to the overall value? It's not always dollar for dollar what it costs.
Good point. And just to quickly touch on one last foundational concept here, commercial property, we should briefly note how it's fundamentally different from residential.
Absolutely. The key distinction is intent. Residential property is primarily for habitation, for living in. Commercial property, on the other hand, is primarily intended to generate revenue or income for its owners. Think office buildings, retail stores, warehouses, apartment complexes. This difference is crucial because it leads to different valuation methods, like the income approach, which is heavily used for commercial properties and different types of leases, financing, and legal considerations. It's really a whole different specialization within real estate. A different ball game, as they say.
Okay, let's dive into a really critical area for the exam and for your future practice. Agency relationships. This is huge. We'll start with a fundamental distinction that came up on your practice test, the difference between a customer and a client. This seems basic, but getting it wrong has big implications. How do we keep them straight?
It's absolutely vital. You're right. It dictates your duties and responsibilities. Here's the simple breakdown. A customer is someone you work with in a transaction, but you do not have an agency relationship with them. You owe them duties of honesty, fairness, and disclosure of material facts, but you don't represent their interests. Think of the buyer when you're the listing agent representing the seller. That buyer is your customer. A client, often called the principal, is someone you work for. You do have an agency relationship with them, established typically through a written agreement like a listing agreement or a buyer representation agreement. You owe a client fiduciary duties.
Right. So client equals fiduciary duties, customer equals fair and honest treatment. It's like your client is your teammate, you're advocating for them. The customer is on the other team, maybe, or just an observer. You treat them professionally and honestly, but your loyalty lies with your client.
That's a good way to think about it. And that duty of fair dealing and honesty applies always to both clients and customers. You can never misrepresent facts to anyone involved. But those higher level fiduciary duties, those are reserved for your client.
Okay, so let's talk more about those fiduciary duties. That word fiduciary sounds pretty serious. What does it really entail?
It is serious. A fiduciary is someone entrusted to act in the best interest of another, placing the client's interests above even their own. It's the highest standard of care recognized by law. These duties are often remembered by the acronym OLD DCRR. Obedience. You must obey the client's lawful instructions. Loyalty. You must act solely in the best interest of your client, avoiding conflicts of interest. This is paramount. Disclosure. You must disclose all material facts relevant to the transaction to your client, even ones they might not ask about. Confidentiality. You must keep your client's confidential information private unless required by law to disclose it. Accounting. You must account for all funds or property entrusted to you by the client. No commingling. Reasonable care. You must use reasonable skill, care, and diligence in performing your duties. Basically, act competently.
And you mentioned loyalty and confidentiality. Do those ever expire, like after the deal closes?
That's a fantastic question, and the answer is crucial. Loyalty, during the agency, and confidentiality last forever. Even years after the transaction is closed and your agency relationship is ended, you cannot disclose confidential information you learned while representing that client. It's an ongoing duty. Violating any of these fiduciary duties is a serious offense and can lead to disciplinary action from the DRE, fines, license suspension, even revocation, not to mention potential civil lawsuits from the client. It really underscores the trust involved.
Definitely underscores the responsibility. Okay, this leads logically into single agency versus dual agency. This was another area highlighted on your practice test, particularly the question about why a broker might choose not to practice dual agency. Let's define them first.
Sure. Single agency is straightforward. The brokerage and its agents represent only one party in a specific transaction, either the seller or the buyer, but not both. This allows for undivided loyalty to that one client. It's also sometimes called exclusive agency. Dual agency is where it gets more complex. This happens when the same brokerage represents both the buyer and the seller in the same transaction. This can happen in two ways. One agent within the brokerage represents both parties, sometimes called direct dual agency, or two different agents affiliated with the same brokerage represent the buyer and seller respectively. In California, both scenarios fall under dual agency because the ultimate responsibility lies with the broker.
Right. And because the broker represents both sides, there's an inherent conflict, isn't there?
Yeah.
How can you be fully loyal to two opposing parties?
Exactly. That's the core issue. In a dual agency situation, the agent's and broker's duties are inherently limited. You can't provide full loyalty or full disclosure to both sides simultaneously. You have to remain more neutral on certain points, like price negotiation strategy. Because of this inherent conflict and the limitations it imposes, dual agency requires the informed written consent of both the buyer and the seller before it can proceed. They have to understand what they're agreeing to. Now, to your practice test question. Why might a broker choose not to allow dual agency within their firm, even though California law permits it with proper disclosure and consent? Many brokers make this choice as a risk management strategy. They might feel it's just too difficult to properly manage the conflicts, or that the risk of misunderstandings or lawsuits is too high. By only practicing single agency, they ensure their agent can always provide undivided loyalty, simplifying compliance and reducing the brokerage's overall liability. Remember, the broker is ultimately responsible for all the activities of the agents under their license. Avoiding dual agency is one way to control that risk.
That makes perfect sense. Prioritizing clarity and minimizing risk. Okay, so timing is everything with disclosures. Let's talk about first substantive contact and agency disclosure. When exactly does an agent need to have that conversation about who they represent?
This is critical timing. First substantive contact is generally understood as the point when the conversation shifts from casual talk to specific details about a property, finances, or motivations. In California, the law requires agency disclosures to be made as soon as practicable. Typically, this means at the first face-to-face meeting with a prospective client or customer before you start acting on their behalf regarding a specific property or solicit or receive confidential information. You'll use specific forms, primarily the disclosure regarding agency relationships, Form AD. This form explains the different types of agency, seller's agent, buyer's agent, dual agent, and must be presented to the seller before entering into the listing agreement and to the buyer before they sign the purchase offer. Then the agency confirmation, Form AC provision, which is actually part of the purchase agreement itself, requires all parties to confirm who is representing whom in that specific transaction. Getting these disclosures done properly and timely is crucial. It prevents misunderstandings, avoids creating an unintended implied agency, and manages potential conflicts of interest right from the start. Everyone knows who's working for whom before any serious steps are taken.
Okay, clear rules for disclosure. Now, what about situations that feel less formal? Let's revisit gratuitous agency and broker liability. This came up on your practice test. Say I'm helping my cousin find an apartment just as a favor, no commission expected. Does my broker even need to know? Are they still on the hook if something goes wrong?
Great question, because this happens a lot. Gratuitous agency is exactly that. Acting as an agent for someone, like a friend or relative, without expecting any compensation. It feels informal, like just doing a favor. However, and this is the absolute key takeaway, even though you're not getting paid, you still owe that person fiduciary duties if you're acting as their agent. And critically, your sponsoring broker is still potentially liable for your actions under the doctrine of vicarious liability. So yes, even if you're doing the favor for Aunt Mildred and no money changes hands, if you mess up while acting in a capacity that requires a license, your broker could still be held responsible. It's like a ripple effect. The broker's responsibility extends to the actions of all their affiliated licensees, paid or unpaid, when performing licensed activities. This is precisely why brokers have robust office policy manuals and require agents to document everything to manage this inherent liability, even for favors. Communication with your broker is key, always.
Good to know. Even favors have professional consequences. Okay, let's touch on the property manager's role. This is a distinct path in real estate. What's their main goal?
The primary objective of a property manager is pretty straightforward: to maximize the financial return on the property owner's investment while preserving or increasing the property's value. They are hired by the property owner, usually under a formal management agreement, to handle the day-to-day operations of a property, most often rental properties, residential or commercial. Their duties are broad: marketing the property to find suitable tenants, screening applicants, negotiating leases, collecting rent, handling tenant relations and issues, coordinating maintenance and repairs, managing property finances, and ensuring compliance with all relevant laws. They act as the owner's agent in all these matters.
So a very hands-on role focused on the owner's bottom line. Okay, let's shift to some absolute critical DRE rules that came up in your practice questions. Commingling versus conversion and required record keeping. These are big ones. Potential license losers. What's the difference between commingling and conversion?
They sound similar, but they are distinct violations involving trust funds, and yes, they are very serious. Commingling is the illegal act of mixing funds belonging to a client, trust funds, with the broker's own personal or business funds. Even if you don't spend the client's money, just having it in the same account as your own money is commingling, and it's prohibited. Think of it like putting your personal groceries in the client's designated grocery bag at the checkout. The mixing itself is the violation because it breaches the trust and makes accounting difficult and potentially inaccurate. Conversion is taking commingling a step further. It's the actual misuse or spending of client trust funds for purposes other than their intended use. It's essentially misappropriating or stealing the client's money. So using our grocery analogy, conversion would be actually taking items out of the client's bag and using them yourself. Both are major violations of fiduciary duty, specifically the duty of accounting, and the DRE takes them extremely seriously.
Got it. Commingling is mixing, conversion is spending. Both are big no-nos. And what about required record keeping? What does California law demand here? How long do brokers need to keep everything?
California has strict record-keeping requirements to ensure transparency and accountability, and to allow the DRE to conduct audits if necessary. Brokers must maintain copies of all transaction documents for a minimum of 3 years. This clock generally starts from the date of closing, or if the transaction doesn't close, from the date of the listing agreement's expiration. This includes things like listing agreements, purchase contracts and addenda, disclosure forms, TDS, SPQ, agency disclosures, inspection reports, escrow records, correspondence, and anything else material to the transaction. Specifically for trust account records, these must also be kept for 3 years. This includes records of all deposits and withdrawals, bank statements, and individual records for each beneficiary or transaction, often called subledgers. There are very limited exceptions for broker funds in a trust account. A broker can keep up to $200 of their own money in the trust account solely to cover bank service charges and fees, preventing those charges from accidentally dipping to client funds. Also, earned commissions can temporarily reside in the trust account, but must be dispersed to the broker within 25 days of being deposited. Following these record-keeping rules is non-negotiable. Failure to do so can lead to disciplinary action, fines, and demonstrates poor oversight, which the DRE frowns upon heavily.
3 years is the magic number. Good to remember. Okay, let's broaden out again to advertising regulations and the critically important fair housing laws. These are essential for staying compliant and ethical. What are some common advertising pitfalls for agents in California?
Transparency and accuracy are key in advertising. One major pitfall is the blind ad. That's an ad that doesn't clearly identify the advertiser as a real estate licensee or fails to state the name of the employing broker. Blind ads are illegal in California. Using a fictitious business name, or DBA doing business as, is allowed, but it must be registered with the county and filed with the DRE. The name can't be misleading, can't imply a partnership if none exists, like using realty if you're not a broker, and generally shouldn't include a salesperson's name unless it's clear they are part of a team under a broker. Speaking of team names, there are rules too. The name must include the surname of at least one licensed team member and use terms like team, group, or associates. It can't use words like brokerage, realty, or associates in a way that implies they are the brokerage. And crucially, all team advertising must clearly and conspicuously display the name and license number of the responsible broker. Beyond California rules, you have federal laws like TCPA, Telephone Consumer Protection Act, which governs telemarketing, including respecting the National Do Not Call Registry and restricting call times, and the CAN-SPAM Act for emails, requiring clear identification, opt-out mechanisms, and a valid physical address. There's even the Junk Fax Prevention Act. And finally, digital advertising. Things like virtual staging are generally okay, but significantly altering photos to hide defects or misrepresent the property without clear disclosure is unethical and potentially violates advertising laws. Honesty is paramount.
Lots of rules to follow there, and this ties directly into fair housing laws. California is known for having very strong protections. What are the absolute must-knows for agents here?
Absolutely. California's primary fair housing law is the Fair Employment and Housing Act, FEHA, also sometimes referred to in conjunction with the Unruh Civil Rights Act. FEHA is significantly stricter than the Federal Fair Housing Act. While the federal law protects 7 classes, race, color, religion, national origin, sex, disability, familial status, HEHA protects 15 classes, adding protections based on ancestry, marital status, sexual orientation, gender identity, gender expression, source of income, veteran military status, and genetic information, among others. Remember, the stricter law always prevails. The core principle is prohibiting discrimination in the sale, rental, or financing of housing based on any of these protected characteristics. Certain practices are explicitly illegal. Steering. This is guiding clients towards or away from particular neighborhoods based on a protected class characteristic instead of objective housing needs. For example, suggesting a family with children would be happier in a certain neighborhood, or only showing properties in specific areas to clients of a certain race. Stick to the client's stated objective criteria. Blockbusting, also called panic selling. This is inducing homeowners to sell by suggesting that the entry of people from a protected class into the neighborhood will lower property values or increase crime. It's illegal fear-mongering. Redlining. This is typically done by lenders refusing to make loans or imposing stricter terms for properties located in certain geographic areas, often based on the racial or ethnic makeup of the area, rather than the applicant's creditworthiness. It's also critical to remember that even individuals normally exempt from fair housing laws, like an owner selling their own single-family home without an agent, cannot use discriminatory advertising. And a specific California point, Megan's Law. Licensees should not research or disclose the location of registered sex offenders. However, they are required to provide buyers with notice about the existence of the public database, where buyers can research this information themselves if they choose.
That's a really important distinction on Megan's Law. And a huge part of fair housing and ethical practice is understanding material facts. Sellers have a duty to disclose, right? What about the agent's duty?
Yes, sellers in California have a statutory duty to disclose known material facts affecting the value or desirability of the property, typically using the Transfer Disclosure Statement, TDS, and the Seller Property Questionnaire, SPQ. But the licensee's duty is even broader. Agents have a duty to disclose all material facts affecting value or desirability that they know or should reasonably know through a diligent visual inspection. This duty extends to both the client and the other parties in the transaction. What's a material fact? Anything that could significantly affect a reasonable person's decision to buy or the price they'd be willing to pay. This includes obvious physical defects, but also things like environmental hazards. Lead paint disclosures for pre-1978 homes are federally required. Potential asbestos or radon issues, California requires carbon monoxide detectors. It also includes public controls or issues like the property being near an airport, in a designated flood or seismic hazard zone, or subject to Melrose taxes. We differentiate between patent defects, things that are obvious and easily discoverable during a walkthrough, and latent defects, hidden structural issues not easily seen, like a cracked foundation hidden by carpet. If the seller or agent knows about a latent defect, it must be disclosed. Then there are stigmatized properties where a non-physical event occurred, like a death, murder, suicide, or maybe even reported paranormal activity. California law has specific rules here. Generally, deaths within the last 3 years must be disclosed upon direct inquiry. However, deaths related to HIV are protected under fair housing laws and cannot be disclosed. The key is whether the stigma might affect value or desirability. If so, disclosure is generally prudent, while always respecting privacy and fair housing laws. Fundamentally, all these regulations, advertising, fair housing disclosures, aren't just hurdles to jump for the exam. They're about upholding the integrity of the real estate profession, protecting consumers, and ensuring a fair, transparent marketplace for everyone. That's the bigger picture.
Okay, let's shift into the legal backbone of almost every real estate deal, contracts. Getting the fundamentals right here is absolutely essential, and this came up in your practice results. I like thinking of the essential elements of a valid contract, like ingredients in a recipe miss one, and the whole thing might fail. What are those 5 key ingredients?
That's a perfect analogy because any one of these 5 is missing. You don't have a legally binding contract. It could be void or voidable. The 5 essential elements are: 1. Mutual assent or mutual consent. This is the meeting of the minds. It means there's a clear offer made by one party and an unqualified acceptance of that exact offer by the other party. 2. Consideration. Something of legal value exchanged between the parties. It doesn't have to be money. It could be a promise to do something or a promise not to do something. Each side has to give or promise something. 3. Legally competent parties. The parties entering the contract must have the legal capacity to do so. This generally means they are of the age of majority, 18 in California, and are mentally competent, of sound mind. Contracts with minors or those legally declared incompetent are usually voidable. 4. Reality of consent. Consent must be genuine and freely given. If a contract is entered into under duress, menace, fraud, misrepresentation, or undue influence, the consent isn't real, and the contract is likely voidable by the injured party. Everyone needs to agree willingly and with accurate information. 5. Lawful objective. The purpose of the contract must be legal. You can't have a valid contract to commit a crime, for example. The contract's objective must not violate statute or public policy.
Okay, mutual assent, consideration, competent parties, reality of consent, and lawful objective. Got it. Each one is a pillar holding up the agreement. Now, contracts often need changes after they're initially agreed upon. Let's talk about contract modification, specifically the difference between an addendum and an amendment, and also revisit the flow of offer and acceptance, especially counteroffers. This is where deals really take shape or sometimes fall apart. What's the difference between adding something versus changing something in a contract?
Great question. Precision matters here. An addendum is used to add new terms or information to an existing contract without changing the original terms. Think of it as attaching an extra page with supplementary details that become part of the overall agreement. For example, an addendum might contain specific financing terms or inspection contingencies. An amendment, on the other hand, is used to change or modify terms that were already agreed upon in the existing contract. You're altering the original deal. For example, if the buyer and seller agree to change the closing date or the purchase price after the contract is signed, they would use an amendment. Both addenda and amendments must be in writing and signed by all parties to the original contract to be legally binding.
And thinking about that initial offer and acceptance, we know an offer can be accepted, rejected, or countered. What's the really critical thing to remember about a counteroffer, especially in California's market where multiple offers are common?
The most critical thing is that a counteroffer is always, legally speaking, a rejection of the original offer. It terminates the original offer and creates a new offer from the party who made the counteroffer. The original offer now becomes the offeree. Now, in California, especially with multiple offers, we often use the seller multiple counteroffer, SMCO form, CR form, SMCO. What's fascinating and crucial to understand here is how it works. A seller can send out SMCOs to multiple buyers. Unlike a standard counteroffer, if multiple buyers sign and return their respective SMCOs, the seller isn't bound yet. The seller then gets to review all the accepted SMCOs and select the one they want to proceed with by signing that specific SMCO again in a designated final acceptance box. Only then is a binding contract formed. It's not first come, first served among the buyers who accept the SMCO. The seller gets the final say after seeing who accepted. Using these standard forms like the SMCO or the seller counteroffer SCO or buyer counteroffer BCO is vital. Agents can fill in the blanks on these pre-printed attorney-approved forms, but they absolutely cannot draft complex legal clauses or substantially alter the forms. That would be the unauthorized practice of law, a big no-no. Agents also cannot give legal advice. Always advise clients to consult an attorney for legal questions. And remember, clauses like time is of the essence. When included, it means deadlines in the contract are strict and must be met. Failure to perform on time can be a material breach.
That multiple counteroffer process in California is really key to understand. Okay, let's move from purchase contracts to leasehold interests. Specifically, let's focus on the estate for years, which sounds like it has to be for multiple years, but maybe not. And let's clarify the California lease rating requirement, as this was on your practice test. Does every single lease need to be written down?
Good points. First, a leasehold estate just means a tenant's right to possess real estate for a specific period, granted by a lease agreement with the owner, the landlord or lessor. It's a right of possession, not ownership. An estate for years is one type of leasehold. Despite the name, it doesn't have to be for a year or more. It simply means a leasehold interest that continues for a definite, fixed period of time. It has a specific start date and a specific end date. Could be 6 months, could be 99 years, could be 2 weeks for a vacation rental. The key is the fixed termination date. It expires automatically on that date, no notice needed. Now, the California lease writing requirement. This is where people get confused. Do all leases need to be in writing? No. Verbal leases for a term of 1 year or less can be legally enforceable in California. However, under the statute of frauds, any lease for a term longer than 1 year must be in writing to be enforceable in court. There's one other wrinkle. Even if a lease term is 1 year or less, if its performance, the end date, is more than 1 year away from the date the agreement was made, it also generally needs to be in writing.
So, while a 6-month verbal lease might be technically legal, is it a good idea? Probably not. Getting leases in writing, regardless of the term, is always the best practice to avoid disputes and clearly define the rights and responsibilities of both landlord and tenant. It's like having that sturdy bridge versus the tightrope, as you said earlier, much more secure. And just briefly, other lease types include the estate from period to period,
or periodic tenancy, which automatically renews for successive periods, like month to month, until proper notice is given, and the estate at will, which has no specified term and can be ended by either party at any time with proper notice, though less common now with statutory notice requirements.
Right, written is always safer. Okay, so agreements begin, but they also end. Let's look at how agency relationships terminate. Your practice test had a question distinguishing agency termination by operation of law versus acts of parties. What causes termination automatically versus when the people involved decide to end it? Like, what if the house burns down? Or what if the client just fires the agent?
Excellent examples that perfectly illustrate the difference. Termination by operation of law means the agency ends automatically due to certain legal events, regardless of what the parties might want. So if the property is destroyed, like the house burning down, or taken by the government through eminent domain, condemnation, the agency agreement for that property automatically terminates. The purpose of the agency is impossible to fulfill. Other examples include full performance, the sale closes, the purpose is achieved, expiration of the agreed-upon term in the agency agreement, death, incapacity, or bankruptcy of either the principal client or the broker. No, not necessarily the individual agent, but the responsible broker, or loss of the broker's license. These events legally dissolve the agency. Termination by acts of the parties, on the other hand, happens because one or both parties take action to end the relationship. This includes mutual agreement, both client and broker agree to part ways, which should always be documented in writing. Revocation bis is when the principal client unilaterally terminates the agency before the agreement expires. This is the scenario in your practice test question. The client fires the agent. Renunciation. This is when the agent broker unilaterally terminates the agency before the agreement expires, essentially abandoning their duties. Breach of the agreement by either party can also lead to termination by the non-breaching party.
So back to that revocation example. If the client fires the agent, even if maybe the reason isn't fair or contractually sound, does the agent have to stop working for them immediately?
Yes, absolutely. Upon receiving notice of revocation for the principal, the agent must cease acting on their behalf immediately. The principal generally have the power to revoke agency at any time, even if they don't necessarily have the contractual right to do so without consequence. If the revocation breaches the agency agreement, like firing an agent without cause before the listing expires, the agent might have grounds to sue the client for damages, like earned commission or marketing expenses, but they still cannot force the client to continue the agency relationship. The agency itself is terminated upon notice. If we connect this to the bigger picture, these termination methods provide clear legal endpoints or off-ramps for agency relationships, whether the goal is met, time runs out, circumstances change, or the parties simply decide to end it. Documenting terminations in writing is always best practice.
Makes sense. And briefly, on the landlord-tenant side, what about landlord remedies for breach of lease and eviction processes? If a tenant stops paying rent, what's the first legal step, and what can a landlord absolutely not do?
If a tenant breaches the lease, most commonly by failing to pay rent, the first step for the landlord is usually to serve the tenant with a formal written notice. In California, for non-payment of rent, this is typically a 3-day notice to pay rent or quit. This notice demands the tenant pay the overdue rent within 3 days or move out. There are similar notices for other lease violations, like a 3-day notice to cure or quit, or a 3-day unconditional quit notice for serious issues. What a landlord absolutely cannot do is engage in self-help eviction. This is illegal in California. It means things like changing the locks, shutting off utilities, removing the tenant's belongings, or physically forcing the tenant out without a court order. Landlords must use the legal eviction process.
So the legal route is called actual eviction. What does that involve generally?
Actual eviction, or the formal legal process, starts with serving the proper notice, like the 3-day notice. If the tenant doesn't comply, pay rent or move out, the landlord then files an unlawful detainer lawsuit in court. If the landlord wins the lawsuit, the court issues a writ of possession, which is then given to the sheriff's department. The sheriff is the only one legally authorized to physically remove the tenant from the premises if they still haven't left. It's a specific legal process designed to protect both landlords' property rights and tenants' rights against unlawful removal. Understanding this process is vital for property managers and landlords. We should also mention constructive eviction, where the landlord's actions or inaction make the premises uninhabitable, effectively forcing the tenant to move out. In that case, the tenant may be released from lease obligations.
All right, let's switch gears to the money side of things, financing and closing the deal. We'll start with something that often confuses buyers early on, and it was on your practice test. Pre-qualification versus pre-approval. What's the real difference and why should a seller care?
That's a great starting point, because they sound alike but mean very different things, especially to a seller evaluating offers. Pre-qualification is usually the very first informal step. A lender asks a potential borrower some basic questions about their income, assets, and debts, usually based on what the borrower tells them, without deep verification. Based on this stated information, the lender gives a rough estimate of how much the borrower might be able to borrow. It's quick, easy, but not very reliable. Think of it like, based on what you told me, you might qualify for this much. Pre-approval is a much more rigorous, formal process. Here, the borrower actually completes a mortgage application, and the lender verifies the information. They'll pull credit reports, check income documents like pay stubs, tax returns, verify assets, bank statements, and analyze debts. If the borrower meets the lender's preliminary underwriting criteria, the lender issues a pre-approval letter stating they are likely to approve a loan up to a certain amount, subject to final conditions, like appraisal and title report.
Okay, so pre-qualification is a maybe based on unverified info. Pre-approval is a much stronger likely yes based on actual verification. That's why a seller takes an offer from a pre-approved buyer much more seriously, right? It shows they've actually done the financial legwork.
Exactly. Pre-approval carries much more weight. It gives the buyer more confidence in their ability to get the loan, and it gives the seller more confidence that the buyer is financially capable of closing the deal. It's a much stronger position for a buyer.
Makes sense. Now, digging deeper into how lenders make that pre-approval decision, let's talk about qualifying ratios. This concept, including a calculation, was part of your practice test. What are these ratios and how do lenders use them?
Lenders use qualifying ratios as a key tool in underwriting to assess a borrower's ability to afford the mortgage payments. There are typically two main ratios they look at. The first is the housing expense ratio, often called the front-end ratio or payment-to-income (PTI) ratio. This compares the borrower's proposed monthly housing payment, which includes PITI, principal, interest, property taxes, and homeowners insurance, to their gross monthly income, income before taxes. Lenders have guidelines for this ratio. For example, for many conventional loans, the PITI payment shouldn't exceed, say, 28% of the borrower's gross monthly income. The second ratio is the total debt-to-income ratio, DTI, or the back-end ratio. This compares the borrower's total recurring monthly debt payments, that's the proposed PITI, plus other long-term debts like car payments, student loans, credit card minimum payments to their gross monthly income. Again, lenders have guidelines. For conventional loans, the total DTI might need to be below perhaps 36% or sometimes higher depending on the loan program and compensating factors.
So using that calculation example from your test, if someone's gross monthly income is $2,000 and the lender's front-end ratio limit is, say, 25%, then the maximum PITI payment they could likely qualify for would be $2,000 times 0.25, which equals $500 per month. Is that the idea?
Precisely. These ratios give the lender a snapshot of the borrower's debt load relative to their income. It helps them gauge affordability and risk. What's fascinating is how these ratios, combined with credit scores like FICO scores, income stability analysis, assets, liabilities, and overall net worth, paint a detailed financial picture. It helps lenders decide if the borrower is not just willing to take on the debt, but truly able to manage it responsibly over the long term.
Okay, crucial numbers for lenders. Now let's talk about specific forms designed to protect consumers in the lending process. The True ID disclosures, the loan estimate, LEA, and the closing disclosure, CD. Your practice test asked about the benefit of these forms. What was the big idea behind introducing them?
The big idea, implemented by the Consumer Financial Protection Bureau, CFPB, was simplification and transparency. Before TRIDE, which stands for TILA-RESPA Integrated Disclosure, borrowers received overlapping and sometimes confusing forms like the Good Faith Estimate, GFE, Initial Truth in Lending, TIL, HUD-1 Settlement Statement, and Final TIL. TRIDE consolidated these into just two main forms, the Loan Estimate, LE. This form provides a clear, easy-to-understand estimate of the key loan terms, projected payments, and closing costs. Lenders must deliver or mail the LE to the borrower no later than the third business day after receiving the loan application. Its format is standardized, making it easier for borrowers to compare offers from different lenders. The Closing Disclosure, CD. This form provides the final, detailed accounting of all loan terms, fees, and costs associated with the closing. Crucially, lenders must ensure the borrower receives the CD at least 3 business days before consummation, the day the borrower becomes contractually obligated on the loan, usually closing. The main benefit, as highlighted on your test, is that these forms make it easier for consumers to understand the true costs and risks of the mortgage before they commit. The mandatory waiting period for the CD gives borrowers time to review the final numbers
ask questions, and compare them to the loan estimate. Lenders also cannot charge borrowers for preparing these disclosures.
So they're really about empowering the borrower with clear information and time to review. Not just more paperwork, but helpful navigational charts for the financial journey, designed to prevent surprises at the closing table.
Exactly. Knowledge and time are key consumer protections built into the Tier ID rules.
Okay, speaking of closing, let's clarify the role of escrow instructions. Your practice test had a question about what happens if these instructions conflict with the purchase agreement. What exactly are they, and who follows what if there's a difference?
Escrow instructions are the detailed, written directions given to the neutral third-party escrow holder, often an escrow company or title company officer, by the buyer, seller, and sometimes the lender. These instructions are typically prepared based on the purchase agreement, but provide much more specific detail. They outline exactly how the escrow holder is to proceed, what conditions must be met before closing, how funds are to be dispersed, which documents need to be recorded, how costs are allocated, etc. They act as the escrow holder's specific marching orders. They must be signed by the parties giving the instructions, usually buyer and seller. Now, regarding conflicts, if there is a discrepancy between the original purchase agreement and the escrow instructions, the general rule is that the most recent document signed by both parties takes precedence. Often the escrow instructions are prepared and signed after the purchase agreement, so they might reflect later agreements or clarifications. The escrow holder is bound to follow the escrow instructions meticulously. They can't deviate without written amendment from the parties. Their role is to ensure everything specified in those instructions happens correctly before the deal is finalized.
Got it. The escrow instructions are the detailed playbook for the closing. Let's talk about the final numbers. Closing costs and proration. This involves calculating who pays for what at the very end, and you had a proration question. What are typical closing costs, and what does proration actually mean?
Closing costs are all the various fees and expenses associated with completing the real estate transaction beyond the purchase price itself. They can add up. Examples include appraisal fee, loan origination fees, points, title insurance premiums for both lender and owner, escrow fees, recording fees, attorney fees, if applicable, pest inspection fees, home warranty costs, HOA transfer fees, and of course the real estate broker commissions. The purchase agreement typically specifies which party pays which closing cost, although many are customary or negotiable. Proration is the process of dividing or allocating certain ongoing expenses and income items between the buyer and seller as of the closing date. It ensures fairness, so each party only pays for the portion of time they actually own the property during the billing cycle for that item. Common prorated items include property taxes, HOA dues, prepaid interest, and sometimes rent if it's an income property.
So, like our earlier example, if property taxes are paid annually, but the closing happens mid-year, proration figures out how much of that year's tax bill belongs to the seller up to closing, and how much belongs to the buyer from closing onward. Seller might credit buyer, or vice versa, depending on when the tax bill is actually paid.
Exactly. It's an adjustment made on the closing statement to ensure accuracy. For example, the documentary transfer tax in California, that's a state-county tax on the transfer of real property, calculated at $1.55 per $500 of value, or $1.10 per $1,000. It's typically paid by the seller in California, but it's technically negotiable. This isn't usually prorated, it's a one-time charge. Understanding prorations is also essential for calculating the net to seller, the final amount the seller walks away with after the purchase price is credited, and all their debits, loan payoff, closing costs, prorated adjustments, are subtracted.
Right, the bottom line for the seller. Okay, one last calculation topic from your practice test for this segment. Interest-only loan calculations and using mortgage factor charts. How do we approach these without getting lost in the math?
They can seem tricky, but the concepts are straightforward. An interest-only loan, also called a straight note or non-amortized loan, means the borrower's periodic payments cover only the interest accruing on the loan principal. The principal balance itself doesn't decrease with these payments. Calculating the monthly interest payment is simple. Use the formula principal loan amount X annual interest rate T12. So for that $120,000 loan at 4.9% interest example from your test, annual interest equals $140,000, 0.049 equals $6,890. Monthly interest equals $6,860. 12 equals $571.67. That's the monthly payment. The $140,000 principal is still due later, typically in a lump sum balloon payment or after refinancing. Now, for standard amortized loans where each payment includes both principal and interest, P&I, calculating the payment is more complex. That's where mortgage factor charts or loan amortization factor tables come in handy. These charts provide a factor for various interest rates and loan terms, like 15 or 30 years. The factor represents the monthly principal and interest payment required per $1,000 of loan amount.
To find the monthly P&I payment, you just look up the factor for your specific loan's interest rate and term, and then multiply that factor by the number of thousands in your loan principal. For example, if the factor for a 30-year loan at 5% is 5.37 and your loan is $200,000, your monthly P&I payment would be 5.37200 equals $1,074. What's really insightful here is understanding how interest works and how much of your payment goes to interest versus principal, especially early in an amortized loan. Knowing these calculations helps you understand the true cost of borrowing and explain loan options effectively to clients.
All right, let's transition to our final segment, looking at the broader legal landscape and how government powers shape what you can do with private property. A good way to remember the main government powers over land is the acronym PEAT. Can you remind us what PEAT stands for?
Absolutely. PEAT is a great mnemonic. P is for police power. This is the government's inherent authority to regulate private activities and property use to protect the public health, safety, morals, and general welfare. Think zoning laws, building codes, environmental regulations. E is for eminent domain. The government's power to take private property for public use, even against the owner's will, as long as just compensation is paid. T is for taxation. The government's power to levy taxes on real property to fund public services. Property taxes are a prime example. E is for escheat. The power of the state to acquire title to private property if the owner dies intestate, without a will, and leaves no known heirs.
PEAT, police power, eminent domain, taxation, escheat. These are the fundamental ways government influences private land. Let's dive deeper into eminent domain. Your practice test linked this to agency termination, which we touched on earlier, and also mentioned easement by condemnation. Can you unpack that connection again? How does the government taking property end an agency deal?
Right, so eminent domain is the power itself. The process of the government actually taking the property under that power is called condemnation. Now, how does this terminate agency? Remember, termination by operation of law. Condemnation is a perfect example. If a property owner has a listing agreement with a broker to sell their property, and then the government initiates condemnation proceedings to take that same property for, say, a new highway, the agency agreement automatically terminates. Why? Because the purpose of the agency, the private sale facilitated by the broker, has become impossible or legally irrelevant. The government is taking the property through a superior legal process, regardless of any private listing agreement. Just compensation is paid to the owner, but the private sale mechanism is nullified by the condemnation.
Okay, so the government's action legally overrides the private agreement. That makes sense. And what's an easement by condemnation?
Sometimes the government doesn't need to take full ownership of the property. We just call taking it in fee simple. They might only need the right to use a portion of the property for a public purpose, like running utility lines or creating a public pathway. In that case, they can use eminent domain condemnation to acquire just an easement, that specific right of use, rather than full ownership. That's an easement by condemnation. The owner still owns the underlying land, but must allow the public use specified in the easement.
Got it. Government power is significant. Now let's clarify some terminology used in describing property boundaries. Meets and bounds and benchmark. These also came up for you. How do these help define exactly what land is owned?
These are methods used in legal descriptions of property. The meets and bounds system is one of the oldest methods. It describes property boundaries by starting at a well-defined point of beginning, POB. This POB is often marked by a physical monument, like an iron pin set by a surveyor, or more reliably tied to a benchmark. From the POB, the description uses meets, which are measures of distance, like feet or yards, and bounds, which are compass directions, like north 30 degrees east. The description then follows a sequence of these courses, a specific distance in a specific direction, tracing the perimeter of the property step by step, until it eventually returns precisely to the point of beginning, closing the loop. Think of it like giving very precise walking directions around the edge of the property.
And what makes a benchmark useful for this? What is it exactly?
A benchmark is a permanent reference point whose exact location and elevation, usually relative to sea level, have been precisely determined by government survey teams, like the USGS, United States Geological Survey. These are often brass discs, set into concrete or other durable structures. Surveyors use benchmarks as reliable starting points or reference markers when creating meets and bounds descriptions or other types of surveys. Using benchmarks ensures accuracy and consistency, allowing future surveyors to retrace the property lines accurately. Both methods provide the precise legal description needed for deeds, title insurance, and resolving boundary disputes.
Precision is key. Okay, moving on to other forms of land use control under police power. Zoning and master plans. How do these shape our communities?
These are primary tools municipalities use to implement police power and regulate land use. Zoning involves dividing a city or county into different districts or zones. Example, R1 for single-family residential, C2 for general commercial, M1 for light industrial, and specifying the permitted uses, building heights, setbacks, minimum distance from property lines, lot sizes, and density within each zone. Zoning ordinances are local laws that enforce these rules. Building codes, often related, regulate the actual construction standards for safety. Master plans, also called comprehensive plans or general plans in California, are broader, long-range planning documents. They outline the community's goals and policies for future development and land use, considering things like housing needs, transportation, infrastructure, environmental protection, and economic development. The master plan provides the overall framework and vision that guides the specific zoning regulations. Planning commissions are typically responsible for developing and updating these plans. If a property owner feels a zoning rule creates an undue hardship due to the unique physical characteristics of their specific property, they can appeal to a Board of Zoning Adjustment, BZA, or similar body for a variance and exception to the rule. These controls work together to promote orderly growth and compatible land uses.
Okay, zoning implements the vision set out in the master plan. Now, let's talk taxation on real estate, specifically focusing on lien priority for property taxes, ad valorem taxes. This was a key point on your practice test. Why are property taxes often called ad valorem, and why do they get paid first in a foreclosure?
Ad valorem is Latin for according to value. So ad valorem taxes are taxes based on the assessed value of the property. Property taxes are the most common example, levied by local governments, for counties, cities, school districts, to fund public services. In California, the assessment process is governed by Proposition 13, which limits the maximum annual real property tax to 1% of the property's full cash value, usually the purchase price, plus adjustments for inflation capped at 2% per year unless there's a change in ownership or new construction, plus amounts needed to pay off local voter-approved bonds or special assessments. Remember the tax payment schedule in California. The fiscal year is July 1st to June 30. Taxes are typically paid in 2 installments. The first is due November 1st, delinquent after December 10th. The second is due February 1st, delinquent after April 10th. Missing these deadlines incurs a hefty 10% penalty. Now, lease priority. Generally, liens attached to property in the order they are recorded first in time, first in right. So typically, an older mortgage gets paid off before a newer one in foreclosure. However, liens for unpaid general real estate taxes, ad valorem taxes, and special assessments have super priority. They automatically jump to the front of the line, regardless of when they arose, and get paid before any mortgaged liens or other private liens if the property is sold through foreclosure.
Why is that? Why do taxes get first dibs over the lender who might have put up hundreds of thousands of dollars?
It's because these taxes fund essential government services that benefit everyone, including the property itself, like roads, schools, fire protection. Granting them top priority ensures governments can collect these vital revenues. It's a critical detail for lenders, buyers, and sellers because unpaid taxes can wipe out other landholders' interests in a tax sale. In California, if taxes remain unpaid, the county can eventually sell the property at a tax sale, though the owner typically has a 5-year redemption period to pay the back taxes and reclaim the property before that happens.
Super priority for taxes. Got it.
Okay, last topic in this segment, easements, focusing on prescriptive easements. How can someone gain the right to use part of another person's property just by using it? And how is this different from actually gaining ownership through adverse possession?
It's a fascinating concept, rooted in historical land use patterns. An easement, remember, is the right to use another person's land for a specific purpose, but it's not ownership. A prescriptive easement arises not from a written agreement, but from long-term unauthorized use. To acquire a prescriptive easement in California, the claimant's use of the other person's land must generally be 1. Continuous and uninterrupted for a period of 5 years. 2. Open and notorious, meaning the use is obvious and not hidden, such that the owner knows or should know about it. 3. Hostile, meaning the use is without the owner's permission. If the owner gives permission, it's just a license, not hostile use. 4. Under some claim of right or color of title, though this element can be complex, if someone meets these criteria, essentially acting like they have the right to use that pathway or driveway for 5 years without permission, they can gain a legal prescriptive easement, the right to continue that specific use. Now, the crucial difference from adverse possession. Adverse possession leads to actual ownership of the property, not just the right to use it. To gain ownership by adverse possession in California, you generally need to meet similar requirements. Open, notorious, hostile, continuous use for 5 years. But D, you also must pay the property taxes on the property you are claiming during that 5-year period. Payment of property taxes is generally not required for a prescriptive easement, which grants only use, not ownership. That's often the easiest way to distinguish them. Disputes over these claims are often settled through a quiet title lawsuit. Hashtag tag outro.
Wow. Okay, we have covered an incredible amount of ground today. We really did plunge deep, didn't we? From those foundational concepts like title versus deed and the different ways to hold property, all the way through agency duties, contract law, leases, financing details, and finally navigating government powers like zoning and taxation. And most importantly, we really focused on those specific areas you identified from your practice test, hoping to turn those tricky points into areas of real strength. Those aha moments, hopefully, are clicking into place now.
Absolutely. And remember, the goal wasn't just cramming facts for the test. It's about building that deeper understanding, the why behind the what. When you grasp the principles, you build genuine competence and confidence. These concepts aren't just abstract test fodder. They are the building blocks for ethical, effective, and successful real estate practice right here in California. Truly understanding this material is what allows you to serve your clients well and navigate the complexities of the industry. Knowledge really is most valuable when it's understood and then applied. You've made great progress today.
Definitely. So as you continue studying and refining your knowledge for the California Real Estate Sales License Test, here's a final thought to mull over. How might mastering this intricate dance, the interplay between these legal principles, the ethical considerations, and the practical real-world application, how might that not only ensure you pass the exam, but also fundamentally shape the kind of knowledgeable, ethical, and client-focused agent you become here in California? Think about that. Until our next deep dive, keep learning, keep preparing, and good luck.